Well, welcome to Justice Served TV. If you didn't know it was us, you would know by my shirt.
Good tip. Hey, the Karen Reed civil complaint was filed. I know you're saying, "Well, wait a minute, that was like a day or so ago." Well, hey, we haven't talked about it yet. So until we talk about it, I mean, come on.
Justice, where are you? Michael and Linda are here.
Love you,
And
Linda.
if the world is justice, will we ever find
The
justice?
courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down me, I lead the way, hoping justice will win the day. Dictionary clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
I'm
All right,
still singing to the song.
it's a doozy. Yeah, some people, there's
Love it.
not everybody will be happy. Some say, "I want the old one back," and some, and then other people are going, I found myself humming, that song after
Yeah,
the fact.
and I love
So
it. I
yeah.
love it.
I think
Okay.
I think they did a fine job with that. So yeah,
Good
so
for
I was
me.
a bit kidding there because obviously we had Mark Betterow on last night and we weren't able to devote the time we needed to the Karen Reed civil case that was filed. But come on,
We look at it this way. Mark Betterow was just fabulous. Look
he's
at
amazing, yeah, and there's no way we're going to push him over for some papers. That's the bottom line.
And you know
Uh,
what happened as a result of that? People posted on X to me, didn't one of the agents that is the best friend of the defendant in the Karen Reed case, that would be Brian Higgins, didn't he testify at the Aaron Hernandez trial? And guess what? I went back and looked at the link to try to find the testimony, and sure enough, he absolutely did
is
testify.
this the Sullivan guy?
This is his name is Matt Kelsch.
Matt
Okay,
Kelsch.
he was an ATF agent. He came in and talked about something with Celebrate and downloads of phones, and he didn't really know very much. His testimony didn't add anything. Ron Sullivan, we developed a cross examination. Ron Sullivan did it. It was very quick because we were, and I posted it. But the intersection of the fact that I'm sitting there in a courtroom now with and rewatching myself just sitting there watching the testimony of the best friend of of one of the defendants in the Karen Reed case, Higgins. And Higgins testified, by the way, that his best friend, Matt Kelch, according to Aiden Carney, who actually posted this, showed him how to use the federal resources to extract messages before destroying a SIM card and tossing the phone. And then someone said back to me, Adam Scott, and I'm going to give the credit to Adam Scott, tagged me on this and said, didn't he testify in the Aaron Hernandez double homicide trial? What are your thoughts on him, Higgins' best friend? So I just thought that was really interesting.
It
So
is
we
a
intersected.
small legal world, as they
It
might say.
is. It
So,
is.
and so, now we have the civil complaint being filed by Karen Reed, and we know Alan Jackson told us it was coming. There it is. It's here. And people are freaking out because there's so many parties involved, and it's so much inbreeding between the criminal case. And the fact is, if you've done, like I've done mass tort litigation in California, I did Prop 65 tort litigation. If you've done any complex business litigation, 18, 20, 30 parties are not unusual.
And when you're doing a 1983 case, which is a civil rights case, and it's related to state counts and commented state counts and all, because actually this is filed in the state, and you can bring a federal complaint. I've done a number of these also. I've reported opinions in the appellate courts on these cases. This is how you plead them. As a matter of fact, we're going to be expecting more defendants, and we'll talk about that because it's a footnote.
Yeah, and it could even happen in relatively, quote, simple cases. I remember when I was a baby attorney, I had a case in
Baby attorney.
California. Where's the baby AI? In California, there are certain parts of the Central Valley that get fogged in like you won't believe. You think you see fog where we are, even in Ireland, you think that's fog? It is literally hang your head out the window looking for what's called the fog line. People may not know that, but that white line that is on the right side of the road as you're driving. That's
Right.
the fog line, because it is so bad in some places where you're creeping along. That's all you can see is that line. It's frightening. I did a case early on where there were 19 people involved in a collision on the freeway there, that just chain reaction, boom, boom, boom. I had one of the big truck drivers, which is never good. We were one of the primary defendants. But can you imagine sorting out that mess? Not just the physical damage, but the physical injury, and I mean, it's a nightmare.
That's the whole point. Is attorneys are used to this, though. They're used to this. And let me just say, public service announcement to Alan Jackson, having done these complaints. This complaint is absolutely fabulously pled. Okay,
Yeah,
and we'll talk about why in a second. But I have some rip and read. I have a big rip and
we have
read
to do
before
that?
we do
Oh,
it.
well,
Can
before
we
we
do
do
that?
that, then.
Well, I was going to say that read, R-E-A-D, kind of will
Rip
push
and
into
read. I get it.
read, rip and read.
I get
But
it.
the rip and read has to do with another case that we're all familiar with, Sandra Birchmore. And again, I disclose that my husband was hired by the civil attorneys, and he's the one who said, that despite what the medical examiner out there had called us, that this was a homicide. Now, he doesn't say who, because that's not what they do. But this was a homicide. That kind of broke this case wide open, and we've talked about that before. But as you know, he has now been charged with not only the death of Sandra Birchmore as being a witness in a federal case, but also with the death of her unborn child, which I was waiting for, because I was wondering, federal court, what are they? And even though Massachusetts state doesn't have the death penalty, the feds do, and they have until January 21st or 23rd to decide whether or not he gets the death penalty. But in between, there was a motion that was just filed, granted by the court, to go over 20 pages to change venue to New Hampshire. Oh, I'm sorry, to Rhode Island. I apologize. To Rhode Island, where he's presently housed. Okay, he's presently in a Rhode Island penitentiary and has to be transported to Massachusetts, which is one of the reasons why I guess they waive transport on a lot of these hearings. But he wants his case to be tried in federal court in Rhode Island, where he is, instead of in Massachusetts. And that's one thing. Okay, we can talk about that. But in these papers, there's his defense. And his defense is, and you called it, Michael Bryant, not as a baby attorney, but as a good attorney here, and as the host of Justice Served TV. His defense is that Michael Morrissey, the Norfolk County DA, has not indicted this as a homicide, that they believe this is a suicide, and he said so, and that the medical examiner for the who's testified for the state, who we've invited on our show to defend her opinion, says it's a suicide. And even though the feds came in with all this other information, still it's holding. Excuse me. You can tell I forgot to turn off my poker phone. Okay. It still says that this is a suicide. Okay. That's the defense. All right. That's the defense. Rip and read. Oh,
Weak. And on the merits of the change of venue, good luck. Good luck with that. The convenience of the defendant and where the defendant is housed, not really going to carry the day, in my opinion.
Yeah, they're saying all the press and the media, but what everybody, the press and media, but you have to find out. You sit there and you try to pick at have you heard about this case? You'll be surprised how many people will say they haven't heard about a case.
No, I don't think
Karen Reed.
Yeah, I think, you're right. People will lie. But I think in reality, this is a far less, front page story than many that we have been talking about in Massachusetts. And so
Massachusetts,
I think it's going to be a problem for them to come up with the goods, surveying, because that's why they want the extra briefing pages, in my opinion. They want to be able to submit all kinds of affidavits or some sort of documentation that we can't get a fair trial. Look at all these people that have already made up their minds in this case. It's just a heavy burden, and I don't see it happening.
I don't see it happening either, but you never know. But I don't see it happening. Change of venues are very hard. We had a change of venue in Jason Williams' basketball player case, and that's very unusual because we did all the surveys. And by the way, they cost a lot of money because you have to do all the actual telephone surveys. You got to submit all the articles. If you just rely on articles, in this world, this doesn't do it. You have to have those surveys to show that almost everybody you call says they have heard about the case and they made up their mind. So
again, I predict denied, but who knows? It is
Judge
but it's still
Judge
Massachusetts.
Bryant. We're going to call it Judge
Yes.
Bryant. All right,
Where's
that's
my
my
gavel? I don't
rip and read.
Okay, so now we're going to go from just rip and read to read.
Yeah, there you go.
And I think I'll bring this up so we can move through this probably more quickly than we might some other stuff, just because it's really a narrative that's really well written. I mean, legal pleading aside, which is well done, it's just it's an easy read. I'll put it that way. And yes,
and when we get to there you go, the complaint. Can you go to that introduction there? All right, before the defendants, just go to the introduction. Then we can go back to defendants. I teach this. In federal court, now this is state court, but in most courts, they don't say you have to do an introduction. I always do an introduction, and I'll tell you why. It's what the judges read, it's what the law clerks read, and that to know what this complaint is about. And once it's almost like the statement to the jury, right? When you're going to try a case, but you're doing it and you're able to frame it your way. So I think we should actually read this introduction, because it becomes really important, because you know what? This is what the press is also going to pick up.
Of course.
This is what this case is about.
And when I looked at it and when I was reading through it, I said, this is a closing argument. That's what this is. This is the closing argument. It's fraught with argument and the alleged facts. But look at it. Just read this introduction. Should I read it to myself? No. First of all, you have to remember that you're writing for a particular audience. Any legal writing should be easy. It shouldn't be a pain, a labor. You shouldn't be forcing the reader to figure out what the hell you're doing and where it's coming from. So you set it up with a nice introduction. For 3.5 years, plaintiff Karen Reed was wrongfully accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for those and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29, 2022. So, and then they go into some great detail. I want to look back here at this footnote's important, as we know.
Footnote is really important.
Footnotes are everything.
But just understand that's what this case is about, to recover for her, right? And let me say to you, Alan Jackson, thank you for giving a promo there for Justice Served. It's a well-written complaint, and
I'm sure
I don't even need to go past page 1 to page 2 with the first paragraph.
Hey, how often do you see a heading complaint with a footnote?
Yeah, no, that's the these 2 footnotes are very important, because
I know they're critical, but you don't usually see it attached to just the header.
Yeah, the plaintiffs are leading off, of course, our favorite person, and the text, and there's probably more coming. We know that from the Brian Walsh case.
Oh my gosh.
Michael Proctor in his personal capacity, because that's how you have to plead what is called a civil rights claim. We'll talk about that. You can't sue a state actor usually under a civil rights claim in federal court if you plan to go to federal court, but you sue it under their individual capacity, even though this is filed in state court. We'll talk about that over the weekend with Michael Del Signor, who is an attorney in Boston, who has been our local go-to guy. Sergeant Yuri Buchanan, in his personal capacity. Oh, man, remember that cross. Lieutenant Brian Tully. So he's not going to be able to hide. He's going to be deposed. Then there's Brian Albert, Nicole Albert, Jennifer McCabe, but we'll talk about paragraph 53 on this complaint later on. Matthew McCabe and Brian Higgins, defendants. And then there's a footnote. There you are. There's your footnote. You love it, but it's right after the word defendants.
Yeah.
What is it?
The Massachusetts State Police in town of Canton will be added as defendants after presentment is made pursuant. And this is basically exhausting administrative remedies. They've got to get that done under the Massachusetts law, and then they'll throw them in as well.
Yeah, and that's important because that's going to bring us to, again, the civil rights, the federal complaints of plea, which are called 42 U.S.C. 1983. And we'll talk about why you can sue individual persons under that when we get to them. But there's also a footnote 2, which over the weekend we'll go more into. And that footnote 2 is...
Yeah, that's this. And this is going to be a very interesting process. And it'll definitely be a question I ask when I'm up there Friday. That is consolidating cases that are cross-county. You know, they're cross-pollinated. It isn't as simple as they're all in the same venue. They're already, you know, in the same system. Let's just shuffle the deck. No, they've got to bring them into whatever the court may decide is the most appropriate county,
Right.
not just the appropriate way to handle all these cases. And here's something else that you know, there was some
And
bluster.
that's by the way is just to remind everybody, what they want to consolidate is the estate of John O'Keefe's complaint, which is in Plymouth County, and this complaint, which is filed in Bristol County.
Exactly. And so one of the things I found interesting was there's been the bluster of these named defendants to bring a defamation action against Karen Reed and Aiden Carney. Well,
that was all for press. That was all for press. They knew this was coming.
But now what they've done, you know, they probably don't know it because they're not bright, but just file when you answer this complaint, file your cross complaint, counter complaint. I can't remember what they call it in Massachusetts. In California, it'd be California would be a cross complaint. But it's basically their opportunity to raise those affirmative defenses and be proactive for their defamation. There it is. They've been given the entree to this.
They didn't know that they were trying to forestall the media talking about this by saying, we're going to sue everybody, including my client Aiden Carney, who said, do it, bring it on. I've been telling you to just bring it on.
So be careful what you wish for. So yeah, I don't care if it was for PR or whatever the purpose was. Here's the perfect entree to do it. You got to answer this anyway. Bring it on.
If you were in New Jersey, we would have the entire controversy doctrine that would say that you can't bring a separate complaint. You must do it attached to something that's there if you've got it. And the court would dismiss it otherwise or consolidate it. So you got it. You got it. You want to do it. You got it.
California would have to make a motion to do that. They wouldn't do it sua sponte, but it's the same concept. We're going to do all this together, folks. You know, we're not going to have these stray parts floating around out there. So how would you like to?
By the way, you talk to other people talking about this. We're talking about this from experience and from a legal end. These are things I'll guarantee you haven't heard about the entire controversy doctrine. And we're going to talk about why you can sue, because I see lawyers out there not understanding why you can sue civil defendants in a civil rights action under 42 U.S.C. 1983. They just don't get it because they haven't done the law as much as we have. But go ahead. You want to go talk about the complaint? I'm like really excited about the individual components of this.
Well, what we have to decide is, because, you know, there's only so many hours in a day, we have to decide how we want to. Would you like to dwell on some of these facts? Do you want to jump into your legal argument?
Why don't we talk about a few of the facts and then talk about what the counts are? This is a 40. Let me just count them again. 46-page complaint.
But 31 of them is this narrative.
It's the narrative, and then we have 7 counts of different claims, and those 7 counts are. After you talk about the narrative, I think I want to talk about the law, but I do want you to go to page. I do want you to talk about number 2, which is the how this complaint talks about these defendants. Okay, I think
you're talking about paragraph 2 or
paragraph 2. Paragraph 2.
Right where we are. Okay.
Right where we are.
And this is, you know, this is nothing new exactly. This is everything that's been talked about, but not in a legal forum, right? Mm-hmm. And now they're laying it out and saying, here's what we're going to prove. And remember, this is not a verified complaint. This is all based on information and belief, which gives you a little latitude in how you argue these facts. If it were verified, you're basically saying, I swear under penalty of perjury, and that's not normal in a traditional filing like this. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29, Mr. O'Keefe was killed in defendants Bryant and Nicole Albert's home at 34 Fairview Road in Canton in an altercation during a late night house party with other defendants, collectively the House Defendants.
This is what I love.
I remember that band. I love
Okay.
that band.
All right, that band. They have now named for the court again because you're controlling the narrative when you file a complaint. The House defendants. So these are all the House defendants. I love how they did this.
That's a nice label.
Whoever was the person who thought of that in the Karen Reed team did a great label with regard to the collectively known as.
So all of that after a night of heavy drinking, the House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about Hawes Long to die in the cold.
And they're not moving away from that. Notice how they're not moving away from that, right?
No.
They're gonna put Cellbrite on trial here for removing evidence that supported what they're saying. So they're going right at it, not away from it. Everybody, like you all thought, oh, they're moving away for it. They have an exit. Right at it. Okay.
Yep. And Ian Whiffin's deposition will be exciting. Anyway.
How's Long to die?
Oh, they moved Mr. O'Keefe's body outside and placed him on the Albert's front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Albert's lawn until Karen Reed found him later in the morning.
This is juicy.
Yeah, I'm just trying to pick and choose here because there are 30 pages of this narrative.
Well, you can go to page 40. You can go to paragraph 55. I know it's a long way away from paragraph 2. Okay.
And I'm just, as you go through this, and I know there will be folks who read this, before they go to bed at night and with a glass of warm milk. But all of these facts and details you're very familiar with. What was what the injuries were to Mr. O'Keefe. That none were consistent with a car striking Mr. O'Keefe. All of this stuff, it's in here.
Yeah,
and then of course,
53, not 55.
The reference to the various texts and the exchange that took place in that first 15 hours. About how the Bryant Albert's not going to take shit for this. He's a cop. All of that. It's all laid out here as we saw it unfold during the course of 2 different trials.
And if you were doing a TV show on it, like the Pit is filmed for every episode, like
it's
an
a real-time hour. It's like the show 24.
An hour.
Yep.
This is almost like a real-time hour for the 16 hours that all of a sudden Proctor said Karen Reed is it. Okay, Karen Reed is the person. So when you're looking at this, if you're filming this as a TV show, that's what you're getting interspersed with. Who may be some of the masterminds in regard to this?
Yeah, and it's we hear the term confirmation bias all the time. This is it playing out in the real world, bit by bit. Let's pin it on the girl, and then everything else is designed to support that conclusion.
So let's go to paragraph 53.
Okay,
because this becomes
hold on a sec, because I don't want to miss anything going between them.
All right. I'm so excited. I'm so excited to read this.
I know that Chloe in this narrative takes a hit as being the instrument of the first attack on John O'Keefe.
You probably should go through that.
Yeah.
I think that's a good idea.
They reference that it's not in this paragraph, but I see Chloe's name in the talk about the dog having a history of attacking people. But when they go into the actual, here's how it unfolded. Chloe takes the hit, the rehomed dog. Let's see. Manufacturing evidence. Yes. Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered, exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor said, Miss Reed is a whack job bleep, retarded, nutbag, and babe with no ass. Proctor further ridiculed and derided Ms. Reed for her serious medical condition, stating that her balloon knot leaked poop. I mean, it's just remembering those moments in trial where Alan Jackson, was just working that stuff out of him, and just accentuating it for the jury to make it
on
even
trial one, right?
even worse. Yes,
right.
trial one, even worse than just seeing it in print. I mean, it was
And someone could
nauseating.
say to you, someone could say to us, okay, well, doesn't he have a First Amendment right to say that? Yeah, he absolutely
Yeah,
has a
of
First Amendment
course,
right to say that.
of
But it
course.
goes to his bias when it comes to him being the lead investigator in a homicide murder case. All right. So that's the difference. You can say it, but then are you biased? Yeah. So, you're not supposed to be biased when you're the lead investigator. You're supposed to let the evidence take you where it leads, not decide who did it and then try to fit the evidence into it. There's been a problem
Exactly.
that's been written about early on in many literature, English literature.
And this is important too when we throw defamation around all the time. Libel, of course, is written defamation, slander is spoken. But in the context of a lawsuit, it's all protected. So anything in this complaint, anything that comes up as a direct result of the litigation is protected. So you have a little more freedom in the context of litigation. So it's not like somebody can say, well, all those things, they've defamed us again. No, doesn't count. Not in this context. There's some italics. So let's look at these. The head of the MSP, Colonel Jeffrey Noble, stated the events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as Colonel, the state police has and will continue to improve in these regards. This is the after the fact. How do we keep from really screwing up like this again? Well, here's a tip. Fire all these assholes. Why don't you try that? Proctor should be the first of many dominoes to go. But I've not seen anything suggesting that's going to happen. Although we have one more officer who is now Mr. Former Good, or is he on administrative leave with pay? We don't know what his role is. He's not one of
the Massachusetts State Police. Yeah.
Yeah, he's not one of the marquee players though. Why is Tully still there?
And Proctor, remember,
was Buchanan still there?
Proctor was trying to keep his job back, and then there's something happened with the Brian Walsh case, which we're going to do a little episode on for the weekend. That all of a sudden, there is more text in the cloud because he didn't realize that when you get a new phone, you've stored everything in your Apple iPhone in the cloud, and there it is for 12 years, 11 years of different things. I can't wait to hear what those are.
No, I mean, I can wait, but I can't. I'm torn. Because I know it's going to be cringy, but important. Right. And so here's the reason he ends up losing his job, violating a Class A felony, not a felony, a violation they call a Class A, which was biased in his dealings with a homicide suspect and or brought himself and the Massachusetts State Police into disrepute. So it's an internal process. They branded him and stripped him of his role, and he's out there, and then he says, "I want my job back." The guts of even asking that amazes me.
This is wonderful. It's like such a symphony. It's a symphony, and Mark Betterow talked about Norfolk County being this whole area. It's such a disgrace. It's disgraced the whole state of Massachusetts in terms of when you think of this case, especially now with this complaint, which we just filed yesterday. This complaint, you've got the Walsh that he pleaded guilty to 2 counts leading just the homicide complaint, leading to the fact that maybe was this not a murder? You've got Birchmore out there, which is in the news, which is leading to many people say disgrace up there as to how they handle that. I mean, he's absolutely right. And then this complaint sets it all out. And what have we done? That we say the Massachusetts State Police, they emphasize, well, we got a problem, but they don't do anything about it.
No, they just say, here's what we should say. They say what they should say, but then they do nothing. And again,
look at footnote 3. Look at footnote 3.
I know, once again, as stated above, MSP will be added as a new party by amendment once the applicable presentation period expires. So, the guy that doesn't have a public presence is Michael Morrissey. Everybody knows who he is. Last time I saw him was in. It was the Father's Day parade. They had a parade up there, Father's Day parade, and he's marching in the Father's Day parade. In all of his grand, bulbous glory. But otherwise, how is he just in the background with all of this stuff happening, how is he not stepping up to take responsibility, to quit, to do something?
Yeah, I
To
mean, even
put his
quit before
face on it.
before the next year's election, and we know that's a big deal. There's candidates all over, including some federal prosecutor named Deitch or Deitch,
Yeah, I saw
who
Aiden is now
but
rallying behind
true, but
him.
he quits his job because he wants to. I mean, he's a federal prosecutor that knows this stuff. I mean, just unbelievable.
Yeah.
So,
And we'll see. You know, I'm a little skeptical. You know, at the electorate. Look what happened with Fani. Sorry, Fani. I'm
yeah,
sorry.
but he's a Democrat, so that's the difference. Funny,
Well, that's helpful. That's
that
helpful.
in a county that is 2-1 Democrat, and that's all.
No doubt.
So,
If it were a Republican, there'd be not a chance in hell. But how does, I mean, considering what had just happened in Fulton County, how does Fani get reelected?
because
Typical man.
because
You know?
it's a Democratic county and she has a big following, and
Well, I think it's
people say-
laziness. I think it's voter laziness. They see her name. They don't go to the next level of figuring out why they see her name so much. It's not positive, and they just vote like robots. I remember
Well,
Fani.
what's the old thing? All press is good press, especially as long as they
Yeah.
spell your name right. They don't
Yeah.
care about the rest, and that's what happens. People hear, Fani Willis, Fani
Yeah.
Willis, Fani Willis,
It's
Fani Willis,
embarrassing.
Fani Willis, and then she gets reelected. Okay, so also you have all of this, but yeah, look at all this. But
Yeah,
there's,
I've kind of rolled through this where we're just really talking about the players and their associations with one another, which
right.
everybody knows. There's nothing surprising in any of this.
Yeah, we're not reading to you every single paragraph,
No.
but there you go. There's your dog bite issue
Here we
on
go.
paragraph
At some
34.
point after entering the house or garage, they left that as a little bit uncertain. Mr. O'Keefe was involved in a physical altercation either inside the house or the garage. I believe garage is where they're going ultimately. During that altercation, the Albert's German Shepherd attacked him. And why would Chloe do that? Why? Apparently, Chloe has that kind of, or had, we don't know about Chloe anymore, had that kind of suspicion of those she didn't know very well or at all. So she's attacked him, and then he's got the dog bites that we've seen so many times. And somehow there's a struggle. Either it's because of the dog attack or because one of the others in that garage helped, hurt, exacerbated. He goes down, and the back of his head hits maybe a step, you know, that sharp edge of a step, and has the contra-crew injury, which of course is,
well, it's an injury to the opposite side of the brain where you hit. So
it's a slosher.
if you hit in the back, your front of your brain's going to be affected.
Yeah,
you know,
because
it moves around.
your brain's kind of floating like in a bowl of Jello
Right.
there, and boom, that kind of injury happens in car crashes.
Right.
It happens in slip and falls, and so that's what we get here. So it's going to be interesting to see this fleshed out, because remember, Judge Bev would not let them get into any of this.
No, she wouldn't let them get into any of it. She wouldn't. But in the civil complaint business, they have to prove it. They will be getting into it.
Of course.
And the whole picture.
They'll have an expert.
And
they're going to have animation.
Right. They're everything. They have everything that's going to be there, and they're going to be able to show it because that's their. It's their case to prove.
Yeah,
okay.
It's their burden, so they get a little more latitude. If I don't side with Bev on much, but her analysis in preventing the defense from doing that at least is more tolerable than if you tried to prevent the prosecution or the plaintiff who has the burden from doing that. But she was still wrong. The Ford Edge, everybody knows Ford Edge, but nobody knows what the hell happened to it because there was never any investigation into that.
Then there's a thing about Higgins. Here you go. Here's on paragraph 38. Let's read this.
This is one of yours? This is one of your favorites? Okay.
Well, I like the last line, of this because it leads to a lot of questions. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night, with 5 whiskeys, if I recall that.
Don't worry about it. Don't worry about that.
Don't worry about that. No, he later told investigators he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snow.
This guy does it all. This guy is a public servant at the highest level. I got to do some big case work, and I got to move cars.
Yeah, and also he was having a relationship apparently with Karen Reed. We learned from the first trial.
He
However,
wished.
or maybe there was more to it. Remember, they met at their house, whatever, blah blah blah.
Mm.
However, the video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face, kind of like I put my face in the blanket here and obscure. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to the other before driving away. Now, what could be in that bag that everyone knew? What could be in that bag? And remember, Higgins is the one who went to an army base, okay, and threw away, separated his SIM card from his phone and threw them both away separately, right? You know, after, of course, he took off the messages between him and Karen Reed to show that, the ones he wanted people to see.
Okay, so let's do some speculating on the large bag.
Yeah, that's what I want you to do. I want
clothing,
you to be a speculator.
I'm trying to think. Clothing. There was an issue with maybe cleanup materials. Remember, I don't have and I think they talk about it in the complaint, so maybe that's where I'm picking up the details. But he lost, Officer O'Keefe lost, I think, like 3 pints of blood. I mean, there's a lot of blood loss, but not found on the lawn, where they found just a few drops, and his clothes did not have much on it either. So where'd that go? Well, if that was part of an accident in the garage and they had to have a cleanup on aisle 5, whatever rags, clothes, whatever they needed. Remember, he didn't have a jacket on either. So if he was wearing one earlier, anyway, a lot of bloody stuff might have been in that bag.
That's a good speculation. That's a good speculation. But if you don't investigate it, you don't know. And especially if you've thrown away your SIM card and trying to and gotten rid of your phone, then what happened to the bag there? Okay. All right. So then they go on to the butt dials and the searches. They go on to the searches.
The searches.
Not backing down from that. Not backing down from that at all. At all. And so the Ford Edge. Now we get to the Ford Edge. Mr. O'Keefe's body was discovered. Blah blah blah. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. And who owned the Ford Edge? Who owned that Ford Edge?
We know there was a similar vehicle owned by, was it by Kevin Albert? I can't remember who it was now.
But it wasn't. But the point is,
was it the kid, Colin?
But the point is that
somebody
no one
knows.
Well, but it wasn't. They just went away from that, and not wasn't investigated. But I think you're going to find out in this case who owned this Ford Edge. I think this is going to come out.
That is such an easy thing to establish in terms of registration, and the testimony that it was there is not enough. You gotta have some more, and I'm assuming that they do or will.
That's what I'm assuming too. All right, so here we go. We're getting down.
We're getting to your magic paragraph. Your 53 is the one you like?
Well, magic, not in terms of the 1983, which is what I really want to talk about it, but magic in terms of guess who they're going to put on trial here besides Proctor and besides the defendants that are here, okay, with Buchanan. We all know that. And we all know about Tully, okay, and we all know about Brian Albert, Nicole Albert. And we sort of all know about Jennifer McCabe, who had a makeover in terms of how she testified in trial 2 versus trial 1.
She definitely had a softer look.
Appearance. But we also know she lied to the FBI. I just want to see how they couch her, because I think how they couch her is really kind of important.
I want to mention just briefly here, Sergeant Michael Lank, who was on the phone, which the dash cam captured, saying that O'Keefe looked like he'd been in a fight. So here's a guy that is not following the narrative, right?
Right.
Did you not get the memo, Lank?
Yeah, I did not get the memo that we're pinning it on the girl and saying that he was hit by a car.
Okay, no vehicle debris, and then we know how the magic tail light continued to evolve and grow.
And that tail light's so important because they now have the jury foreman talking about how all the jurors, the first thing they wanted to see were the pieces of the tail light, and they realized that tail light wasn't the same as when it, with the car was picked up. One day we have to ask juror number 1 to come on the show. I think he was an amazing juror. Yeah,
no, I think he was a character and perfect for that role. I know there's been some some buzz now about how the guy should never have been allowed on the
Oh, it's
jury,
bullshit.
that he
Yeah.
misled when he was
Oh, he
answering
didn't.
the questions,
He did
blah,
not.
blah, blah.
He did not. That's all.
Well, that's what you
That's
say
all
if you're
the.
a loser.
Yeah,
That's
it's
what you
all.
say.
Come on. That's ridiculous. And there we go. Paragraph 46. Sergeant Lank was a
That's with Lank
longtime friend of the
again.
Alberts.
Yeah.
He spoke to the Alberts case pursuant to their plan. The Alberts and McCabe's told Lank that Mr. O'Keefe never entered the Alberts house, even though, remember, Ian Whiffen had that circle that he had found that he didn't put in his report that showed the phone had entered the house. Remember that?
And every
Wiffle
bit of
ball?
his all of his testimony. I mean, I can't give him credit for some of his testimony and diss the rest. I'm dissing all of it. But even he left, 32 steps here and 81 steps there, and he left open the possibility that yes, even by his account, there was an opportunity for O'Keefe to go into the house. It
I
fits
don't think it was a
within his
possibility.
parameters.
I think it was in that circle. I think it was a piece of evidence, but he didn't put it into his report because it didn't fit the narrative that they wanted to fit.
But he testified about it.
But he had to testify about it in cross-examination. That's
So-
how he had to testify about it, because he wasn't bringing it up and the prosecution wasn't bringing it up.
And it does put you in a weird position when you're arguing his testimony at the end, because you're saying this guy has no clue what he's doing. He's contradicting himself. And then, oh, by the way, here's something we think you should believe. It makes it a little
yeah,
muddy.
except that he contradicted himself because he took away the search by creating new software that took away how long to die in the cold being at 2:27 a.m. All
The
right.
tab, the
So
whole tab
that
information,
goes
I
the
know.
whole point, that he took that away and he didn't testify as to what the exhibits really showed, because he was going with the prosecution.
Well,
So really,
he improved the software, Linda. He improved it.
I
He
know.
made it so much better than it was.
He's a
Kind of like the $6
genius.
million man.
He's the genius, according to those videos that we.
Hey,
talked
leave my
about.
girlfriend alone. Leave my girlfriend Heather out of this. Okay. Michael Proctor signed to the case, blah, blah, blah. Yes, yes, yes. All of the likely subjects. I mean, Tully, I think, is getting a greater pass than he should. And he's the guy pulling the strings.
No,
he's the
he's a
guy
good
directly
friend.
responsible for Proctor, period.
Yeah. He's
And
a
he's
defender
not taking
here.
any hit for that. Or did he
Yeah.
get 5 days off? Whatever they gave him.
Whatever it was, but remember, he's not.
Mechanic had the 5 days off, too.
They didn't call him. The state didn't call him. They were trying to keep the defense away from cross-examining him. Okay.
Yeah, and then they talk about how Proctor's connected to the Albert family. They're basically like a second family. Yep, we get all of that.
Right, and if you were a judge in a case, you're supposed to remove yourself with that kind of connection, because that's called a conflict of interest.
Yeah,
anyone ever hear that term? Conflict of interest is kind of important. People should pay attention to it, especially judges.
Norfolk County does not worry about those things. Don't.
Well, and cops and judges really have to pay attention to it.
And there are two kinds. There's the appearance of some conflict, and there's actual conflict. Well, here we have actual conflict. They don't even care about that. They're like,
if we were in New Jersey, even the appearance of conflict is considered something. Even if you think of the word appearance of conflict, could I have a conflict? That means you're out. Okay,
Yeah.
That means you get out of the case. Okay. Now, people tend to push that, but that's the law.
Well, that's the right thing to do, because why do you want that cloud hanging over any case? Any case, just remove yourself so it doesn't bog down the process, and maybe you actually get to the right result, because that's
and
not
the only time you don't have to
distraction.
do it is if you're a lawyer and your client says, "I don't care if there's a conflict with you and
You
somebody
get a waiver
else.
on that.
I
sure.
don't care." You get a waiver, but that's a waiver that's freely given, and that's from a defendant or somebody you represent in a civil case, as opposed to the prosecution by the government in a murder case.
Yeah. Yep. So here we are.
Paragraph 53. It's
Dun,
coming.
dun, dun.
Look at this.
Jen.
Okay. The House defendants taking it full advantage of the fact that they, the interviews were untimely and unrecorded and designed to help the House defendants. So now the House defendants, we get to one of them specifically, Jennifer McCabe became the point person for the House defendants in providing their false narrative to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never acts of an innocent witness seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy and among a group of people with a shared goal of deflecting their criminal exposure onto someone else. There you go. The heart of it right there. Jennifer McCabe, the mastermind coordinator for the House defendants scheme to pin it on the girl, along with the scheme developed by Proctor.
Yep. The most hated of the bunch. Jen.
Right, and her friend, remember her friend who also testified
Carrie,
before a grand jury,
Carrie.
And I say lied, prevaricated. She said she was mistaken.
No,
she didn't
she was confused.
misunderstand. She was confused.
Very complicated question.
One or the other. It's one or the other, but it didn't look good.
Okay, so let me talk about the text messages. All of this is foundational stuff for the conspiracy. Remember, conspiracy, whether it's civil or criminal, once you have these predicate acts, you have to have people doing something in furtherance of the conspiracy. Well, there's so much here. I mean, that's
take us
that's
a day.
not a toughie.
Take us a day, right?
Yeah.
It's gonna actually, if we did this, it'd be like trying a case. It would take us weeks.
Yeah. There are so many bits and pieces.
Right. We're trying to give you the overview here. I mean, you can go through with other people and read every single.
And I suggest you do if you want, if you want a refresher.
Right. It's a good refresher. We're trying to give you the overview of the whole effect, because when you try a case before a jury, what you're looking for when you open is the effect. What's the theme? What do you think? You get that in paragraph 1. These are the high points that are going to pull together when you're looking at the effect that you're trying to get to the jury. So when they go into that jury room and discuss these little tidbits, those tidbits show that they come to a conclusion that the plaintiff, by a preponderance of the evidence, it doesn't mean 51%, it just means a little bit over 50, has proven their case of the 7 counts that we're going to lay out here beyond, to the jury's satisfaction.
So they focus in this part of the complaint on the Higgins-Reed love affair, I'll call it, and the mystery kiss. And in 59, rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and, of course, parking those cars, as he does as part of his job. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and the MSP not investigate what Higgins was doing or what was in the bag, what's in the bag, but they went as far as to hide this video from Karen Reed and her criminal defense attorneys for years. And we you forget all of the malfeasance that unfolded over time because there's just so much. Right. And one of it was, or many of them involved these videos that, remember the Sally Port, can't have it. And when you get it, it's inverted. And where's the 42 minutes that are missing? I mean, it's just, it boggles the mind how much there is.
And in the mix of this is, just the criminal case. Remember, Miss Dever, don't call me Devers, get my name right. It's Dever.
Private citizen Dever.
Citizen Dever, who, thank God, at least she's not carrying a gun for the purposes of being a police officer, but she still may have a gun. I mean, it's the way it is in the world.
So they talk about Higgins dropping off his cell phone and the SIM card, as you've talked about already. And a lot of this part of the complaint is about their failure, what they didn't do. They didn't speak to this person. They didn't speak to that person. 62, for example, as he prepared to question Chris and Julie Albert on the 10th of February, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. Well, that's normal. When you're interviewed by the cops, you would normally give them like a gift card Perhaps some sort of dinner out. That's I don't know why people make a big deal of that.
Well,
Anyway,
I see nothing wrong with giving them a piece of pie or something like that, but
I can't
think we're
imagine.
talking about that. Here, you're saying, would you like while you're interviewing, would you like a piece of cherry pie that I made? And they'll usually say, if they're a good couple.
Who are you, Aunt B? This is not Mayberry. I mean,
wait a second. I cook all the time, but here's my burn from last week's cooking.
Oh my gosh,
my burn scar.
Somebody, Alan Jackson burned his hand cooking some stuff too, didn't he?
Yeah. I mean, that's exactly what happens. I mean, if you're, you get close to the fire, if you're cooking, you shouldn't be close to the fire if you're a cop.
Maybe that's some sort of symbolism.
But maybe if you're close to the fires, you have to do it. You have to make sure that that's what you want to do, because or else you end up here.
Yeah, I think there might be some symbolism, because Alan Jackson is he's deep into the fire.
Well, then how come I burned my? Was I a sympathy burn? Is that what you're saying?
Yeah,
sympathy burn for my former opponent.
Yeah, I hadn't thought of that.
Who, by the way, if you didn't watch our interview with Alan on our show, because it was the first time that I ever interviewed him, we hadn't spoken since the Spectre case, and I think you'll find that it's fascinating. And he told us this was coming. He said this was coming.
Yeah.
He thought within the next few days, certainly within a week or so, and that's exactly what happened. This was coming. Thank you, Alan, for giving us that information, spilling the tea on our show, and it was truthful, because I know after he said it, people were like, "Oh, Alan Jackson said it's coming, and it's 3 days, and we haven't seen it complain." People are nuts on Twitter. I'm just finding that I see these comments.
Is that a revelation to you?
Talking about it is a revelation to me, because what are you talking about? What are you talking about? Before you file a complaint, you got to make sure it's well done.
Oh, I like the phone reference here. Proctor seized Ms. Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's office conclusion that the manner of death could not be determined, and that there were no injuries to Ms. O'Keefe's body consistent with the vehicle strike, which of course
the important part.
Ms. Sordi-Bello, she testified to that.
Yeah, even if she couldn't determine, let's talk about this a second, because even if she couldn't determine a cause of death, what she could determine was that there was no injuries that were as a result of a vehicle strike. Those are two separate independent conclusions. Okay, not being able to determine the manner of death. The cause of death was easy. Not being able to determine the manner of death, which is, and you've talked about the natural, accident, suicide, homicide, or undetermined is not really. It's the four.
Yes, if you don't know, then it's number 5.
So undetermined manner of death. But she was able to determine within a reasonable degree of medical certainty, and that's a pretty strong conclusion, that there were no injuries consistent with a vehicle strike. And consistent is very loose. I mean, anything could almost be consistent. And there was none, zero, a zip.
Yeah. So, and I credit her for that. She did not follow the narrative,
And she got attacked. She got attacked by Hank Brennan, if you recall, on cross-examination.
Mr. Brennan, it's been a while since I've done Mr. Brennan.
But yeah, he was Hank. He hanked all over her.
Yeah, but it is her witness, Now I can see going after or replacing your witness in the Birchmore case. If I were the prosecutor there, I would just replace the medical examiner. If the defense wants to call them, then you can cross-examine them. But if you put your witness on the stand, which is what they did here, and then you attack her basically because she said there were no injuries consistent with the vehicle strike, really? I mean, come on. I mean,
yeah.
It's
not a good position you want to be in. There's no way. In fact, if I were Mr. Brennan, I probably would have just let it lie and move along.
No, if I would have said, I would have called another medical examiner that said there were injuries. Okay, because maybe you can find somebody.
Oh, I'm sure you can find somebody.
I have a feeling, okay, that there's a lot of Brady material out there. I have a feeling that maybe they did call a bunch of people and they couldn't find any medical examiner who would say that there were injuries consistent with the vehicle strike and that they didn't turn it over. Now, that's just a feeling. I don't know. But boy, wouldn't that be interesting if that existed?
Yeah, that's a tough negative to prove, but you're right.
But you get that. Sometimes
you have to believe they looked.
Yeah, sometimes you get that.
And they spent the money.
Yeah.
But hey, that would be shocking that there was no medical expert that would be willing to bend their opinion to the narrative. I'm glad to hear that if that's what happened.
I'm glad to hear it too.
Okay.
But it'd be interesting to know if they went elsewhere and got those opinions. It was even important, not that they it would be if they got other opinions that said, no, I agree with the medical examiner's conclusion, and they didn't turn it over. That's what I'm,
Well, if they're smart, and that's a huge if, when you're having those conversations with a would-be expert, you make sure they don't put anything in writing. Nothing in writing, no reports that should be turned over, and I'm giving them the benefit of the doubt that if
but
have
they
them, they
can't.
should turn them over.
And Brady, if they have an oral opinion that says that, or just a consult, and they haven't hired the person, you still have to turn that over. You have to turn it over.
But that's harder or virtually impossible to prove.
Unless the person who was a contact comes forth and says, yes, okay, or you get a hint of it and you go talk to the person.
Again, that's a mother to prove.
Well, I'll tell you what. I mean,
I'm not counting on them doing the right thing.
I just can't believe that with the 2 trials that they didn't try to find somebody. I can't believe it.
Looking, okay, there's the videos that we've talked about. 42 minutes. If there's somebody out there that knew nothing about this trial, read these 46 pages. You will have saved yourself about 2 years of your life, because it's all in here. And even the things, I start to see stuff and I go, oh yeah, all right. There was just so much stuff that to keep it all cataloged in your brain is difficult. But this is a nice, I would call it a primer, but it maybe goes even further than the primer. About what exactly was done or wasn't done. And you can dispute some of these facts because they are being effectively argued on information and belief. But I don't think they're being too loose with the facts here.
No, they've got these facts. They've got this. They're not. This is not. And what's going to be interesting here is going to be depositions, right? I hear somebody. There was somebody I read on X who said, "Well, Karen Reed's never going to testify in this case. She's going to take the Fifth Amendment." What the?
Who said that?
I have no idea. I just had passed these comments. What are you talking about? Of course she's going to get deposed. Of course she's going to testify. But so is everybody else. Michael Proctor, Yuri Buchanan, Lieutenant Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins, and then those from the Canton and the Massachusetts State Police who are going to be added, peoples. Oh boy, I tell you what, this were my case, I'd be dying to do deposition.
This is a career case in terms of the time, money, and man hours that have to be invested into this. It's a lot. It is just, it's nonstop. You could have a firm that this is all they do. This case, once it really starts rolling, once the other party answers, because you can't do anything until that happens. But then when the discovery begins in this, man, duck quick. This reminds me, as I'm thinking about the depositions and the transcripts, and I'm thinking about the ASAP Rocky transcripts that we've requested from the court, and this is very interesting. I didn't even tell you this. We've been busy with other stuff. The one court reporter that first reached out, and first of all, anybody who wants to try and get a transcript from a trial in Los Angeles County, good luck. They have a list of probably 70 court reporters they use, and you make the broad request for a transcript, and then you see who answers you. I've had 3 different court reporters answer me that they've covered part of the trial, and I get that. That makes sense. The first one said, I can't give you anything. All the sidebars are sealed. And so we will, when we can, bring a motion to unseal them, because there's no basis to. I mean, you have an
What did the
acquittal.
second and third? What did the second and third say?
They just said one said, well, do you want the whole trial transcript? I think she's seeing dollar signs in her head because, folks, this stuff's not cheap.
It's like $2 a page at least.
And as a former spouse of a court reporter who knows more than I need to about the process, they earn every dime. And I have no problem
I love
paying.
court reporters. A good court reporter is fabulous. And a bad court reporter can screw up the record and make something that you said is something else or missing.
What do I say about the court reporter, the most important person in the room? Yeah. So the second person said, well, I'd have to look for what exactly are you looking for? No reference to them being sealed. Interesting.
Yeah.
I didn't offer that. I said, well, I'm looking for sidebars that relate to the conflict of interest alleged or the gag order. Seems to me, and the third one, which I just got yesterday, said, well, it'd be very expensive. My time is valuable to be just finding those parts that you're looking for. I wrote back, well, my ex-wife was a court reporter, and I know you have search functions. Can't you just search gag order or conflict of interest and just see what comes up? How much time would that take?
Right.
We know it was talked about briefly in open court, but it was primarily sidebar material.
Right.
So don't give me that. You'd have to be, you'd have to go through the whole trial transcript. No, you don't. You don't have to do that, not manually. So we're still working on it. We'll see what shakes out. But interesting
Right.
that the last
We're on
two that reported did not say, oh, they're all sealed. Maybe
By the way,
really
really dismissed his suit against ASAP Rocky, his civil suit. He's continuing on with this defamation suit
What an
against
idiot.
Joe Tacopino. We're going to have Joe on our show the Monday night before Thanksgiving next week. It's a show you're not going to want to miss.
Yeah, that's right. I forgot we have that penciled in for next week, don't we?
Next Monday. Yeah,
Weren't we taking the week off?
we were taking the week off. We can't.
Well,
because we penciled Joe in.
Yes,
and
if we
tell you that.
If that, I know, I totally forgot about it. If that penciled in becomes ink, we're doing it. So, Joe, if you're listening, you're not off the hook, buddy. We're still doing that.
And by the way, all of our viewers who we said we were going to be there, all right, spread the word that we're probably going to be there Monday night.
Oh my gosh, I totally forgot. Well, we'll remind folks.
Okay,
because we're zooming along here, I want to get to your legal issues.
Just get the legal. We have the seven counts. Okay, here.
Give me the one you want to hit first.
I just want to hit one because they're all gonna. I can just tell you what they all are and then go back to the points. So the 7 counts. Let me start with the first page of the 7 counts. Count 1, and this is what I'm going to talk about. This is the 42 USC 1985, the 1983 malicious prosecution, and then I'm going to also talk about the next count, the 42 USC 1983. And if we look at that, this one, by the way, took up a lot of space. The count 2 is supervisor liability against Buchanan and Tully in their individual capacities on that same statute. Count 3 is a really important one. It's the 42 USC 1983 conspiracy to deprive Miss Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, McCabe's, and Higgins. But just hold that thought for a second, because there are other counts, but they're kind of like they're kind of like duplicative in the sense of count 4 is the same counts for under the Massachusetts Code. Count 5 is a malicious prosecution under common law. Count 6 is intentional infliction of emotional distress. We all know about that. And count 7 is a civil conspiracy, basically under common law. But what I want to talk about,
there is some overlap, not to those most recent, those
Right.
last ones. Those are standalones, but there is some overlap, and there is some alternative pleading here, and that's fine. That's not unusual.
But what I'd like to talk about is the whole idea of the conspiracy under count 3 that we have
Let
here.
me pull that one up here. Stand by.
Okay. And this would be a good ending, really, to our show.
There you go. Conspiracy to deprive Ms. Reed of her Fourth Amendment rights. Now, people might say, Fourth Amendment, that's a police thing, and this is a civil case. And okay, so explain how that all works.
Okay, so and this is a federal statute, okay, and you can plead a federal statute in state court. You don't have to go to federal court to do it. You can plead that you have your rights to do that in federal court. And I've seen this, and the reason I want to comment is, I've seen this on the internet. We're here to correct the record. I have tried 42 USC 1981 and 1983 cases for conspiracy and violation of civil rights. I have won them. I have, when there's been a dismissal before we get a trial, I've gone to the appellate courts. I have reported decision. They've come back and I have won them, or they've settled. I know the statute. I know how to plead it. I know what the issues are with regard to immunity and everything like that with the police and all. But what's important here is that people have been saying you can't put a civil person, a normal, not civil, a normal citizen, or you and I, like a Michael Bryant or a Linda Kenny Biden. You can't put normal people who aren't police officers into a 42 USC, whether it's a 1981 or 1983 count, because that relates to the cops. That's absolutely wrong. 42 1981 is actually the conspiracy statute, but that has a year. So they're going under 42 USC, and they're going to try to say there was a conspiracy that actually caused an actual deprivation of rights. That's under the 42 USC 1983. And we can talk later on about maybe they had some problems with 1981, but they all merge if indeed the conspiracy is effective. You can, and here's how this goes. All right, this statute was basically as a result of the civil rights movement in the 1960s. All right, where Black people went to sit at lunch counters, and it arises out of that. So you go and sit at lunch counter, and the owner of the lunch counter or the server won't serve you. Why? Because you're Black. That's the way it was back then. There is a cop also at the lunch counter. He doesn't enforce the law and say you can't not serve them. That's a violation of the Constitution. That's discrimination. You must serve them. So the cop stays silent, or the cop agrees and says, yeah, that's right. You can't be served. I'm going to arrest you if you don't get out of here and you don't get off those lunch counters. All right. And that's where the statute arrived from, so that the conspiracy goes because there is a cop involved, and it involves normal citizens, and you can bring them in under this statute. All right. This is extremely important for people to understand. And I wish it stopped being that misinformation out there that says you can't do it. Yes, you can. It's been done for, let's see, 40, 60 years, over 60 years. There's a history behind it. Start reading, start learning, and start paying attention to what is really the law. All right. I've said my piece because I'm really big on the statute, and I'm really big on the fact that people don't seem to understand that the conspiracy under the statute relating to a constitutional right can include the fact that the police either were actively involved or failed to prevent something that they knew about that was illegal.
Yep. Very powerful stuff if you know how to wield it. And it looks like in this complaint, they definitely do. So obviously, we will be following this. I can't wait for the answer and to see if the named defendants have the balls to file a cross complaint, counterclaim, and bring out all of their whining about the defamation they say took place. Because, Katie bar the door, as they say.
Right.
Because be careful what you wish for in your deposition.
Yeah, and we're going to see if this complaint does what it says it's meant to do, which is justice served. All right, so please hit that, because we all want justice to be served. Please hit that subscribe, like, share, and notify button. Please do it right now. I'm going to give you time. Also, if you like this, I have to show this because people are telling me they like these shirts. I'm wearing one of the shirts. All right, check out our merch store. Yes, we're also purveyors of merchandise, along with telling you what the law is. But that's because we're a TV show, and we get to do that.
So nothing like hawking goods for Christmas. All right, or for whatever holiday you want to celebrate.
Well, I like to hawk justice being served, and congratulations on a very well pleaded complaint.
Yes, they did a fine job, and I can't wait to watch it unfold. Next step, of course, this Friday, the case that's been underway, not the new one, which is in Bristol, but the other one in Plymouth. I'll get a picture of the Rock. Maybe I'll do a little short of Plymouth Rock while I'm there.
It's going to be a tiny picture.
See. Here it is. I'm holding the Rock. It's I will be.
I think you're going to be there, and then I'm going to join you on the 6 o'clock wrap up show. Yeah. I had promised. Initially we are going to stream it. Okay, Michael's going to be on. He's going to get his interviews. Missy's going to stream it, and all. But I won't be sitting there with Michael. But you know what? He's going to get these interviews, and he's going to pop up, and you're going to want to focus on that. And then I'll come in at 6 o'clock and interrupt them all the time.
Yes, and I'll be. We haven't figured out yet. It's maybe weather dependent. Whether I stay up there for our 6 o'clock or whether I hit the road to come back. Either way, we will do a follow-up wrap-up.
The mobile studio.
Yes. Yeah. So that'll be fun. That'll be Friday before we head into our sort of week off.
Well, sort of depending on if we have Joe Tacopino, we won't have the week off, and you'll be joining us.
Cool. All right, then. You heard the lady. Go and hit the like and the subscribe and all of those other things.
The lady now. I can't believe it.
The lady. Hey, lady. We are Justice Served TV. Please try to do the right thing.